Alright, this is an Act, 97th Congress Act, an Act, Section 1. This Act may be cited as the Federal Oil Gas Royalty Management Act of 1982. Your table of contents, short title, table of contents, finding appropriate definition, Title 1, Federal Oil Management Enforcement. Duties secondary, duty of lasers, operators, motor vehicle transport, required record keeping, proper disbursement of royalties, explanation, payments, liabilities of bonding, hearings, investigation, inspection, civil penalties, criminal penalties, royalty, interest penalties, and payments, injunction, specific enforcement authorities, rewards, non-competitive oil, gas lease royalty rates. Title 2, State and Indian Tribes, Application Title Cooperative Agreement Information, State suits, state suits under federal law, delegation of the state, shared civil penalties. Title 3, General Provision, Secretarial Authority Report, Study of minerals, relation to other materials affected to date, funding and the statute of limitations, expanding royalty obligation severability. Title 4, Re-enlistment with leases, conversions, unpatented oil placer claims. Section 401, Amendment of Mineral Landings Lease Act of 1920. Alright, now continuing with, findings and purposes. Section, Congress finds that the Secretary of Interior should enforce effectively uniformly existing regulation for the mineral leasing laws, provide with the inspection, production, activity leases on site of the federal Indian lands. State accounting of the respective royalties, other payments due, and owning and oil, gas produced such lease sites for the erotic, inadequate, and essential for the Secretary initiative procedures, improved methods, accounting such royalty payments to provide routine inspection activities related to the production of oil, gas on such lease sites. 4. Secretary should aggressively carry out the trust responsibility for the administration of Indian oil, gas. Is the purpose of this act to clarify, reaffirm, expand the define of the responsibility obligation leasers, operators, and other persons involved with the transportation, sale, oil, gas, federal land, initial Indian lands, other continental shelf. Clarify, reaffirm, expand the define the authorities, responsibility, Secretary of Interior, implement and maintaining royalty management system, oil, gas leases of the federal lands, Indian lands, outer continental shelf. It's to require development and enforcement practices for the ensure the prompt, proper collection, disbursement, oil and gas revenues owned by the United States and Indian leasers, that those inuring the benefit of the state, to fulfill the responsibility of the United States for the administration of Indian oil, gas resources, and to effectively utilize capabilities of the state Indian tribes developing, maintaining, an efficiency effective with the federal royalty management system. Definition, Section 3. For the purpose of this act, the federal land means the land interest of the land owned with the United States, which is subject to the mineral leasing, including mineral resource of the mineral estate, the reserve of the United States, with the conveyance of the service of the non-mineral estate. Non-mineral estates. Indian allot means the Indian who land and interested in land is held on trust in the United States, who holds the title of the subject of the federal restriction against alienation. Indian lands may be delayed for the interest of lands, Indian tribe, and Indian allot that holds in the trust of the United States, in which subject to the federal restriction against alienation, include the mineral resources, mineral estates, reserved for the Indian land, Indian allot, with the conveyance of the surface of the non-mineral estate, except the stuff that does not include any land subject to the provision Section 3 of the Act of June 28, 1906. Indian tribe, or Title 34, Statute 539. Indian tribe means Indian tribe, band, nation, Pueblo, community, Rancherio colony, and other group of Indian, including Metatalical Indian community and that with the Indian island reserve, which in the land with the interest of the land with the child with the United States with the trust was subject to the federal restriction against alienation. Lease means the name of the contract, profit share with arrangement, joint venture agreement issue approved by the United States under the mineral leasing law with the authorized exploration, extraction, and removal of an oil lease site means the land submerged, including the surface of the served mineral estate of which for the exploration, extraction, and removal of the oil and gas authorized pursuant to the lease. A leaser means a person of the United States, an Indian tribe, and Indian allotment that issues the lease that any of the person have assigned the obligation to make the royalty or other payment is required by the lease. Mineral leasing law means the federal law administration secretary authority disposition lease for the oil or gas. Oil or gas means oil or gas originating from and allocated outer continental shelf, federal or individual Indian land. Outer Continental Shelf has the same meaning as provided by the Outer Continental Shelf Lands Act of Public Law 95372. Operator means any person, including the leaser, who has the control of which manages operations on oil and gas lease sites on federal and Indian lands Outer Continental Shelf. 12. The person performs an individual form of corporation, association, partnership, consortium, or joint venture. 13. Production Means of the activity take place for the removal of the oil and gas, including such removal of the field operation, transfer oil gas off the lease site with the operating, monitoring, maintenance, and work over drilling. Royalty means a payment based on the value of the production, which of the United States and Indian tribe of the Indian allotment of the production of the oil and gas from the outer continental, federal or Indian land, or any minimum royalty owned by the United States of the Indian tribe, Indian lot under any of the provisions of the lease. Secretary means the Secretary of Interior and his designee. State means for the several states of the Union, of the District of Columbia, Puerto Rico, the territory of possession of the United States, of the territory of the Pacific Island. All right, Title 1, Federal Policy Management Enforcement. Duties of the Secretary. The Secretary shall establish the comprehensive inspection, collection, fiscal production, accounting, auditing system, and provide with the capability accurately determining oil and gas royalties, interest, fines, penalties, fees, deposits, other payments. Owned and to collect and account with such amounts of the timely manner. Secretary shall establish procedure to ensure the authorized properly identified representative of the Secretary will inspect at least once annually with each lease site with the producing inspect of the produced significant quantities of oil and gas in any year which has the history of the non-compliance applicable provision of law and regulation, establishing and maintaining adequate programs providing for the training and such authorized personnel representative and method of technique of the inspection and accounting that will be used to implement this act. Lease and accounting audits. The Secretary shall audit with reconcile with the extent of the practical with all current with the past lease accounts, the lease of the oil and gas, take appropriate actions to make additional corrections, refunds, and warranted. Secretary shall conduct audits and reconciliation of the lease accounts for conformity with the business practice of the record keeping system which are required for the leaser by the Secretary for the period covered by the audit. Secretary shall grab priority auditing those accounts identified with the state or Indian tribe as having significant potential of the underpayment. The Secretary may also audit accounts records selected by the leasers and operators. Contracting authority. The Secretary may enter with the contract with the other appropriate arrangement that independently certified with the public accountants. They undertake the audits, accounts, and records for the any leaser and operator relating to the lease of oil or gas. Selection of the independent certified public accountant shall be competitive bidding in accordance with the Federal Property Administrative Services Act of 1949, except that the Secretary may not enter into the contract or other agreement with the independent certified public accountant to audit any leasers or operator which for the leaser or operator is primarily audit client and such a certified public accountant. Alright, available secretarial material, all books and accounts, final records, reports, files, and other papers of the Secretary used by the Secretary which are reasonably necessary to facilitate the audit required under this section should be made available to any person, governmental entity conducting audits under this Act. Alright, duties of the leasers, operators, and motor vehicle transporters. Title 30 U.S. Standard Code 1712, Section 102, a leaser who is required to make the royalty for the other payment under the lease under the material law, leasing law shall make it such a payment for the time and the manner may be specified by the Secretary and shall be notify the Secretary in the time and the manner as may be specified by the Secretary assignment of the leaser have made with the obligation to make it a royalty of the other payment under a leaser under the mineral leasing laws. Any operator shall develop and comply with the site security plan designed of the product, the oil and gas produced, stored on shore or leasing site from that and which plan shall conform with such a minimum standard, such as Secretary may prescribe the rule, taking into account with a variety of circumstances as to the lease site, with the develop and comply with such minimum site security measure for the security that deems appropriate for to protect the oil and the gas produced and or stored at lease site on the outer continental shelf from theft. No later than the 5th business days after beginning productions anywhere with a lease for the site of the allocated lease site with a resumed production in the case of which has been off production for more than 90 days. Notify the Secretary in the manner prescribed by the Secretary of the date at which the production has begun and resumed. 2. Any person engaged in the transporting motor vehicle and oil from any lease site with an allocated with the lease site with a shall carry with the on person his vehicle with the immediate control with the document showing the minimum of the amount of the origin intended for the destination of the oil. Any person engaged with the transporting oil and gas by pipeline for the lease from any lease site with the allocated with the lease site with the federal Indian land shall maintain documentation showing the minimum amount of origin intended for the first destination of such oil and gas. Required record keeping. Title 30 U.S. Standard Code 1713, record report, information, inspection, duplication. Section 103. A leaser or operative of the other person directly involved with the developing, producing, transporting, purchasing, selling oil or gas subject to this act throughout the point of the first sale, the point of the royalty computation, whichever is later shall establish and maintain within any of the records, make any of the reports, provide any information to that the Secretary may be, by rule, reasonably required for the purpose of the implementing act, determining compliance with the rules under the orders under this act, implying the request for any of the officer employed with the designated of the Secretary in each state with the Indian tribe, conducting the audit and investigation pursuant to this act for the appropriate records and reports of information which may be required by the section that should be made available to the inspection duplication such officers and employee of the state of the Indian tribe. Records required by the Secretary with respect to the oil and gas leasing for the federal Indian lands outer continental shelf shall be maintained 6 years after the record was generated unless the Secretary notified the record holder that has initiated an audit investigation involved with the search for the records that has the records must be maintained for a longer period. In a case case where audit investigation underway, records shall be maintained until the Secretary releases the record holder of the obligation to maintain such records. Prompt disbursement royalty. Section 104. Section 35 of the Mineral Lands Lease Act of 1920 is amended and deleting as soon as practicable after March 31st, September 30th of each year by adding the end of the payments to the states under this section respect to any money received by the United States shall be made not later than the last business day of the month with such monies are warranted by the United States Treasury to the Secretary that have been received, except any portion of such money for which would undergo challenge to place within suspense of the account pending on the resolution of the disposition. Such warrants shall be issued by the United States Treasury no later than 10 days after the receipt of the such money for the Treasury money placed in the suspense account which is determined may be payable to the state will be made no later than the last business day of the month in which such dispute is resolved. Such amount with the placed in the suspense account with the pending of the resolution shall bear interest until the dispute is resolved. Indian land royalty deposits. Title 30 U.S. Standard Code 1714 deposits royalty funds derived from the production of oil and gas from allocated to Indian lands shall be made and by a Secretary appropriate Indian account with the earliest practicable date after such funds are received by the Secretary of the case later than the latest business day of the month of which if the funds are received. Title 30 U.S. Standard Code 1714 note. The provisions of this section shall apply with respect payments received by the Secretary after October 1st, 1983 unless the Secretary may by rule prescribes an earlier effective date. Explanation of payments. Title 30 U.S. Standard Code 1715, Section 105. When any payment, including amounts due for the receipt of the royalty bonus for the interest, charge, or fine, or rental is made by the United States with respect to the oil and gas lease of the federal lands deposited with the appropriate Indian account on behalf of the Indian tribe of the Indian lot with respect to any of the oil and gas Indian lands, they should be provided together with such a payment, the description of the type of the payment that may be being made, the period covered by such a payment, source of such a payment, the production amount of the royalty rate, unit value, and the trust of the information that may be agreed with by the Secretary of the recipient state, Indian tribe, and Indian allotment. This section takes the respect of the payments made by the after October 1st, 1983, unless the Secretary by rule prescribed an earlier effective date. Alright, Title 30 U.S. Standard Code 1716 Liabilities and Binding, Section 106. A person, including an agent employed with the United States with an independent contractor authorized to collect from the receipt of the account with the authorized handle of the money for the able to repay the received by the Department of the Interior of the derived of the sale of the leaf and any other disposal of the oil or gas should be liable to the United States any losses caused by international reckless action, inaction, such for the individual with respect to such money in the case of the independent contract required as the Secretary deems necessary to maintain the bond to demonstrate the amount of money from which the individual could be liable to the United States. Hearings. Title 30 U.S. Standard Code 1717, Section 107, hearings, investigations. In carrying out his duty for the act of the Secretary must conduct for the investigation other inquiry necessary for the appropriate may conduct for the after notice the hearing and the audit necessary appropriate to carry out his duties or out of this act. In connection with any of the such hearings, inquiry, and investigation on the audit of the Secretary authorized where the responsible actions. Affidavit that requires special general order. Any person submit with the writing of the affidavit that answer the questions if the Secretary may responsible prescribe the submission shall be made within such a reasonable period under an oath, otherwise it be necessary to administer the oath. Your subpoena to, if required, a subpoena to attend with the testimony of the witness for the production, all books and paper of the production, financial record, documentation matters, materials, have the Secretary may request. 4. In order to testimony to be taken to dispositions must be any of the person designated by the Secretary who has the power to administer oath to compel the testimony of the production of evidence of the same manner authorized under the paragraph 3 of this subsection and to pay the witness for the same fee the mileage is paid, and the like of the circumstance for the courts of the United States. Refusal to obey subpoena. In the case of the refusal of the subpoena served upon any of the person under restriction under the section district court of the United States for any of the district in which the such person found resides and transacts business, application for the Attorney General requests Secretary after notes the such person have the jurisdiction issue for the under ordering requiring such person to appear with give the testimony before Secretary to appear, produce documents before the Secretary. Any failure to obtain orders in such order of the court may be punished by a court a contempt for the subject of the penalty up to $10,000 a day. All right, Title 30 U.S. Standard Code 1718 Inspections. Section 108A1. On any lease site with the federal Indian lands, any authorized properly identified representative of the Secretary may stop and inspect any motor vehicle that he probably called with belief of carrying oil or from a lease site on a federal Indian land allocated to such a lease site with a proposing to determine whether the driver of such vehicle that has documented related to such oil required by law. Authorized properly identified representative of the Secretary of law enforcement officer alone may stop and inspect with a motor vehicle which is not on a lease site if he has probable cause to believe the vehicle is carrying oil from a lease site on a federal Indian lands allocated to such a lease site. Such inspection should be for the purpose of determining whether the driver and such vehicle have documentation required by law. Authorized and properly identified representative of the Secretary may, without advance notice, enter upon with the travel across and inspect lease for the federal Indian lands may obtain with the operator immediately acts if the secured lease facilities on such a lease site for the purpose of making inspection investigation, determining whether the compliance with the requirements of the mineral leasing laws and the Act. Secretary shall develop the guidelines set forth and coverage for the frequency of such inspections. Alright, for those purposes of making the inspection investigation under this Act, the Secretary shall have the same right to enter the upon with the travel across the lease site with the leaser of the operator has acquired with the purchase condemnation, and otherwise. Alright, civil penalties, non-compliance with the requirements of the inspection, Title 30 U.S. Standard Code 1719, Section 109. Any person after review the violation, after such of the violation, have the reported subparagraph that AO fails to review to comply with the requirements of the Act with the mineral lease law, rules, regulation thereunder, determines that any of the lease of the permit is issued thereunder, fails to permit the inspection authorized in Section 108, and shall fails to notify the Secretary in assignment under Section 102 to A2, but it shall be liable with a penalty up to $500 per violation each day. Such violation continue the day of the dating from the date of such notice of the report. Penalty under the subsection may not be applied to any other person who is otherwise liable for the violation in paragraph 1. If the violation is discovered, the report of the Secretary or the authorized representative of the liable person corrected within 20 days of the such report, such longer time, the Secretary may agree that after the due notice of the required for the paragraph 1 has been given to such a person, the Secretary of its authorized representative, such person has corrected the violation within 20 days of such notification, such longer time, the Secretary may agree to. If the corrective action is not within taken in 40 days or longer period, the Secretary may agree that after due the notice report with the referred subsection A1, such person shall be liable to civil penalty not more than $5,000 per violation each day, with the violation continue the day with the day of such notice or report. Any person who knowingly willfully takes making a royalty payment of the date with a specified state, street, regulation, order, and the terms of the lease, fails to refuse the permit, law, entry, and inspection and audit, knowingly, willfully fails to refuse to comply with the subsection 102B3, such liable penalty up to $10,000 per violation each day, but such violation continues. False information. Any person knowingly, willingly prepares and maintains, submits a false, inaccurate, misleading report, news, affidavit, the records of data with any written information. Stolen or unlawfully removed oil and gas. Knowingly, willfully takes, remove the transport, use of the diverse oil, gas from lease for having the valid legal authority to do so. Purchase or accept with the sell, transport, conveys to another. Any oil, gas, knowingly have the reason to know that such oil, gas was stolen, unlawfully removed, and diverted, shall be liable to penalty up to $25,000 per violation each day, but the violation continues. No penalty under this action should be assessed until the person of the charge with the violation have to give the opportunity for the hearing of the record. The amount of any of the penalty under this section finally be determined the deduction from any of the sums of the United States with the person charged. On a case-to-case basis, the Secretary may compromise to produce civil penalty under this section. Notice under the subsection shall be the personal servant of the authorized representative of the Secretary, registered mail, and any person in the manner prescribed by the Secretary, designated the representative receiving any of the notice of the subsection, determining the amount of the such penalty, whether they should be remitted or reduced in the amount of the Secretary shall state the record and reason for the determination. Review of administrative record. Any person requested for the hearing in accordance with the subsection time of the Secretary prescribed for the hearing of the grave of the final order of the Secretary under this section may seek review of the such order in the United States District of the Judicial Court in which the violation allegedly took place. Remove the district shall be only the administrative record do not de novo, and such any action should be barred unless filed within the 90 days of the Secretary final order. Failure to pay assessments. If any of the person acts unpaid of the assessment civil penalty under this act after an order of making an assessment has become final order, if such a person does not file a petition for the judicial review in accordance with subsection J, and after the court of active brought through the subsection J has entered the final judgment in favor of the Secretary, the court having the jurisdiction to award amount of the assessed plus the interest of the day of the expiration of the 90-day period referred to the subsection J judgment by the court shall include an order of the pay. No person shall be liable to civil penalty under subsection A and B with the failure to pay rental or any lease automatically terminated pursuant Section 31 of the Mineral Leasing Act of 1920. And that was Title 30 U.S. Standard Code 188. Civil penalties. Title 30 U.S. Standard Code 1720, Section 110. Any person who commits to the act of civil penalty provide 109D with the shall give the upon conviction to be punished with a fine not more than $50,000 or imprisonment not more than 2 years or both. Royalties, interest, and penalties and payments, Section 111, and this is Title 30 U.S. Standard Code 1721 and Title 26 U.S. Standard Code 6621. Section 11.1a. In the case of the oil gas lease for the royalty payment is not received by the Secretary of the date, such of the payment are due less of the amount of the due the Secretary shall charge the interest of late payment with the underdue payment is the rate applicable under Section 662. 1 of the Internal Revenue Code of 1954, in case of the underdue payment, the partial payment of the interest shall be computed with the charge only on the amount of the deficiency, not on the total amount due. Any payment made with the Secretary of State under Section of the 35 of the Mineral Lands Act, Leasing Act of 1920, any of the other payments made by the Secretary to a state from any oil gas royalty received by the Secretary which is not paid on the day of the required under Section 35 include the interest charge computed with the rate applicable under Section 662 with 1 Internal Revenue Code of 1954. Title 26 U.S. Standard Code 6621 Internal Deposit Indian Account. All internal charges collected under this act under the other applicable laws because a non-payment, a late payment, underpayment of the royalties owing an Indian tribe or Indian allotment should be deposited in the same account as the royalty with respect to which the interest is paid. Indian royalty funds and late deposits. Deposit royalty funds may be made by the Secretary under the Indian account which is not made by the day of the required under subsection 104B shall include the interest rate charge computed after the rate of applicable under Section 662(1) Internal Revenue Code of 1954. Title 26 U.S. Standard Code 6621, notwithstanding the other provision of laws, no state will be assessed for the interest of penalties found with due against the Secretary of failure to comply with the Emergency Petroleum Allocation Act of 1973 regulations, Secretary of Energy, thereby concerning crude oil certification of the pricing with respect to the crude oil taken from the Secretary of the kind of the royalty. Any state with a share of the overcharge resulting from such a failure to comply shall be assessed against money for the found to be due with the owing of the such of the state of the result audit for royalty accounts for a transaction which took place prior to the day of the enactment of this act, exempt that after the completion of such audit, sufficient monies have not been found due to owing to any state of the state shall be assessed balance of the state share of the overcharge, and interest shall be charged under this section only if the number of days of the payment is late. And that was Title 46, 26 U.S. Standard Code 6621, and Title 15 U.S. Standard Code 751, no. Title 30 U.S. Standard Code 191, General, the first sentence of the Section 35 of the Act of February 25th, 1920 is amended with inserting the including interest charge collected under the Federal Oil Gas Royalty Management Act of 1982 between the royalties and. Injunction Specific Enforcement Act Authority. Civil Action Attorney General, Title 30 U.S. Standard Code 1722. Alright, Section 112A, with addition of the other remedy with the Act of the Aiming and Releasing Law of the Attorney General of the United States with the designee may be civil action with the District Court of the United States with which may have jurisdiction over such actions that either restrain any violation of the Act and compel to the taking of the action required under this Act of any of the Mineral Leasing Law of the United States. Civil action described in subsection A may be brought only with the United States with the district court with the jurisdiction wherever the action or mission of the transaction constituting violation under this act with any other mineral leasing law occurred wherein the defendant is found to transact business. Reward, section Title 30 U.S. Standard Code 1723, and we're in the Section 113, where amounts representing royalty, other payments owned by the United States with respect to any of the oil, the gas lease on the federal lands, outer counter, and also the recovered pursuant to any of the acts of the Secretary under this act with the result of the information provided by the Secretary by a person of the Secretary with authorized paid as such for the person amount of the equal to not more than 10% of the recovered amount of the preceding sentence that shall not apply with the information provided by the officer with the employee of the United States, an officer or employee of the state of the Indian tribe acting pursuant to the cooperative agreement of delegation under this act, any of the person acting pursuant to the contract authorized by this payment, authorized by this act. All right, the non-competitive oil gas lease royalty rate. Section 114, Secretary Directive of the conduct throughout the state with effect of the change of the royalty rate under Section 117C of the Mineral Leasing Law Act of 1920, exploration, development, and the production of oil and gas, and B, overall revenues generated by such change. Such studies shall be completed and submitted to the Congress within 6 months after the date of the enactment of this act. And that was a study in Title 30 U.S. Standard Code 226, submitted to the Congress. Title 2, States and Indian Tribes. I'm going to cut the tape there.